Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below.
Can a legal permanent resident who has stayed outside of the United States for a year or more return to the United States?
Let's find out. The problem with a legal permanent resident or LPR staying outside of the United States for a year or more is that if they intend to return to the United States, they will face scrutiny by a Customs and Border Protection officer. This is because the trip outside the United States lasting for a year or more, creating a rebuttable presumption that the LPR abandoned legal permanent resident status. If the LPR cannot overcome the presumption by the officer will either try to convince the LPR to confirm abandonment of his status, or place the LPR in removal proceedings, where an immigration judge will decide whether the LPR abandoned their status based on the circumstances of travel. If the judge is convinced that the LPR abandoned status, the judge will issue a removal order that has the effect of taking away legal permanent resident status from the non-citizen, and authorizing immigration customs enforcement agents to physically remove the non-citizen from the United States.
What are the removal proceedings?
Although an intimidating process, all is not necessarily lost if the LPR is facing removal proceedings based on a potential abandonment of status. First, the government has the burden of proving by clear, unequivocal, and convincing evidence that the LPR status has been abandoned. This is not necessarily an easy burden for the government to meet. Furthermore, while proceedings are pending, the LPR retains their status until the judge makes a decision. The judge will hear testimony and weigh evidence as to whether abandonment occurred. The judge will consider all circumstances surrounding the LPR's life and the trip, including the LPR's U.S. family and community ties, the LPR's U.S. employment, the LPR's filing of U.S. income taxes as a resident, the LPR's intention to make the U.S. their permanent home. This can include maintenance of a U.S. mailing address, existence of U.S. bank accounts, possession of a valid U.S. driver's license, property ownership, and management of a business in the U.S. However, a judge may also consider circumstances indicating abandonment, such as the LPR's extended or frequent absences from the United States, the LPR disposing of property, or terminating a job in the United States before leaving, the LPR's family, property, or business ties all located abroad, the LPR's conduct while outside the United States, such as working for a foreign employer, voting in a foreign election, or running for political office in a foreign country, the LPR's failure to file U.S. income tax returns. It should be noted that any circumstances indicating non-abandonment can and should be raised with the Border Patrol officer first, to attempt convincing the officer that the LPR did not abandon status, and potentially avoid removal proceedings. Regardless, even if the officer still places the LPR in removal proceedings, the officer's findings are not binding to a judge. Furthermore, the LPR will be given time to prepare the presentation of his case, to demonstrate that legal permanent resident status was not abandoned.
How can I prevent a finding of abandonment?
First, you can apply for a re-entry permit. If the LPR knows that he will need to stay outside the United States for a year or more, the LPR must file Form I-131 and apply for a re-entry permit with the United States Citizenship and Immigration Service. This will establish the LPR's intention to permanently reside in the United States after a travel of long duration, potentially avoiding a finding by a Border Protection officer that the LPR has abandoned permanent resident status. Another option is applying for a returning resident visa, an SB1 visa. If the LPR lived in the U.S. for more than 1 year, and did not apply for a re-entry permit, or the trip outside the United States lasted for more than 2 years, the LPR can apply for an SB1 visa, in order to be able to come back to the U.S. to resume residency. The LPR can generally apply for the SB1 visa at a U.S. consulate abroad. The LPR will generally have to show the following. The LPR had the status of a lawful permanent resident when departing the United States. The LPR departed from the United States with the intention of returning, and has not abandoned this intention. The LPR is returning to the United States from a temporary visit abroad, and, if the stay abroad was protracted, this was caused by reasons beyond their control and for which they were not responsible. For example, medical reasons. The LPR will need to fill out Form DS-117, and the consulate will schedule an interview to make a decision on the application. The LPR is expected to submit supporting documentation with the application, such as proof of ties with the U.S. For example, tax returns, evidence of economic, family or social ties, and proof that the protracted stay outside the U.S. was beyond the LPR's control. In the case of a trip lasting beyond 1 year, it is recommended to consult with one of our immigration attorneys to obtain guidance as to the best steps to take to preserve legal permanent resident status. Although the best situation is to apply for a re-entry permit before travel, as indicated, there are options such as obtaining a returning resident visa or to even challenge a finding of abandonment where we can certainly help. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.